like to tell you I'm happy to be here, but why start with an untruth? Bryan Kohberger's case has a lot going on behind the scenes now that that case has been moved to Boise, Idaho, out of Moscow. What really is going on in the case right now?
As we look ahead in the Idaho 4 case, a lot has changed, and what does it mean? I'm Lainey Law.
And I'm attorney Andrew Myers.
And today we have the pleasure of once again being joined by Kevin Curtis, attorney from Winston and Cachet Lawyers. How are you doing today, Kevin?
I'm doing well, thank you, and thank you for having me.
So we brought Kevin on today to talk to us about some of the questions we have in the Idaho 4 case and what's been going on.
Yeah, I have a bunch of questions for you, Kevin. I mean, you're out there, we're here in New England, and we know what we hear and read. But from what you've seen now that the Bryan Kohberger case has moved to the Boise, Idaho court, way down in the southern part of the state, do you have any initial impressions from what you've seen as to whether this case will see any new direction at all?
I don't know that it will necessarily see a new direction. The trial date was, while it was in Latah County, it was scheduled for June. The judge in Boise now has moved that back with jury selection starting, I believe, in late July with trial date in August. I think we have seen the move is going and has created a little bit more of a sterile environment, so to speak. Because of the change of venue. This is a judge who is not really all that familiar with either side's attorneys. The attorneys are not as familiar with the judge as they are in Latah County.
I don't think any of you, other than Ms. Massoth, have appeared in front of me before.
Thank you, Your Honor. My name is Bill Thompson. I'm the Latah County prosecutor. This is Ashley Jennings. She's my senior deputy. And then we have Mr. Nye and Ms. Beatty from the Attorney General's office, and then we have victim support staff with us.
All right, thank you.
Yes, sir.
Defense?
Ann Taylor, attorney for Bryan Kohberger, Elisa Massoth, and Jay Logsdon, counsel for Mr. Kohberger as well.
So even with the physical aspects of the courtroom, the much larger courtrooms, kind of a more neutral or a little less emotion-packed scenario for both the motions and the trial to take place, it does take a little bit of a different tone from that standpoint.
Yeah, one of the very first things that the judge had said, he welcomed all the attorneys, and I think all but one of them had never, ever been in that courtroom. Up in Moscow, a lot of people said it was a good old boys club. I hate to use that phrase, but apparently the judge and William Thompson even went to college together. They were a member of social clubs together. Does that make a difference where there's now no real personal relationship between the judge and anybody on either of the teams?
Sure, it makes a very large difference. We're all guilty of first impressions, but we all form them. And so when you're in front of a brand new judge, and particularly in a case of this magnitude, how you appear, how you present, trying to figure out what is permissible or what draws the court's ire, it's all brand new from both sides, from the bench to the attorneys to the bench. When you're in a one-judge county, so to speak, and you've been in front of that judge many times, there's probably a little bit more room. You're familiar with how the court makes decisions, how they rule. You're familiar with their body language, how they speak, what that conveys. So now you don't have that. Neither side has really much of an advantage one way or the other on it. But it certainly changes the dynamics. It changes perhaps sometimes even in the manner how you write in your pleadings and briefings, how aggressive or not you may be. So I think it has a substantial impact as the parties and the judge feel each other out. And we'll see that develop as more of the substantive motions, pleadings, discovery battles come up over the next 8 to 10 months.
One of the very first things that Judge Hippler said when he had the very first hearing in this case was, these aren't his exact words, but he said pretty much, I wish I could say I'm happy to be here, but why start with a mistruth?
All right. I'd like to tell you I'm happy to be here, but why start with an untruth? I am accepting of my responsibility to be here. I want to go over with you some expectations of mine.
My reading of that was he wasn't happy that he got that case dumped in his lap. Other people, some of our commenters have corrected me and said, no, that's not what he meant. What he meant was, it's kind of like when you see somebody at a funeral and you say, oh, it's good to see you again, but I'm sorry about the circumstances. A, which impression is right, if you know? And B, what did you read into that comment that he made?
I don't know for a fact, but I have a relatively strong belief that it is the latter, not the former. I think he wanted to make sure that his first comments were ones that recognized the gravity and the tragedy associated with the death of 4 students, and now the legal system is determining whether somebody's guilty of those crimes, and if so, whether they should be executed. So I think he was speaking to the gravity of the case itself.
About 30 days after the case went to the Boise, Idaho court, the I-Corps court system had an entry that said, here's how you can apply to get sealed documents. And I thought, well, that's kind of strange. And I thought about it for a few days, and I said, maybe this is one of those things that if I don't apply, later on, I'll be sorry that I didn't. So I did. I have it right here on I don't have it up on the screen, but on October 16th, I put in a request. The court said, here's a form that you can use to request to inspect, duplicate, or transcribe exempt or sealed records. So I filled it out. I gave him my name, my contact information, and I listed the documents that I want. And I was honest. I said, for objective analysis by an attorney, they wanted to know why I wanted this stuff, who's been practicing for 30 years. But I was honest. I said I used for legal evaluation on our podcast. And I have not heard back. I know there's another creator out there who put in her request, and it's already been denied. And I fully expect that my request will be denied. I'm just waiting. But it's one of those things, like I said, if I hadn't done it, I would feel like, I should have at least tried. But why do you think the court is allowing these requests? And do you think that there's any chance at all that they will allow information that's been sealed to be revealed now?
Well, I think that's a great question. And I saw that document as well, and I didn't follow up on it as you have. My best estimate is that he is reviewing what has taken place in the case, both from the standpoint of getting himself familiar with the pleadings, the briefings, the motions, etc. But he also is most likely looking at the court's prior decisions to seal records. He's looking at those records to see if circumstances have now changed to where the initial rationale for sealing them maybe has gone away, if it had to do with issues relating to the initial indictment or charging issues. And secondly, perhaps even to see if he agrees with the judge's initial rulings that there was, in fact, good cause under the court rules to seal those records. So perhaps he is doing a review and will do a partial release of some of those records. Certainly, some records we know won't really get unsealed, and those relate to the defense funding, defense requests for investigations, things like that, which will remain under seal.
Have you ever seen anything like this in all your law history, in a situation where you can request documents like this?
No, I mean, I haven't seen. It's unusual the amount of documents that have been sealed, because they clearly go beyond simply defense funding and indigent defense funding and preparation. I can only speculate, as others do, that some of it relates to some aspect of witness safety or security at some level, but no, the amount of sealed documents is unprecedented in my practice. And then secondly, the court issuing the order that we're just discussing is, to me, reflective that they are doing something in terms of reviewing the amount of priorly sealed.
Well, yeah, we all know that one of the reasons for keeping things under seal is to preserve the integrity of the investigation, to preserve the secrecy of, for example, secret informants. And we know there's a secret informant. We've talked about that before. And we know that, in my view, anyhow, I think that Dylan Mortensen and Bethany Funk hold the keys, because very little has been said about them. There was one affidavit that said Bethany had some exculpatory information. So sure, I guess arguably, even though I'm a former reporter and I want everything to be out in the open, I guess I do, now that I've been to law school and practiced law for 30 years, I do understand why things need to be kept under seal. But are you saying seriously that this judge might actually be taking a look at just the knee-jerk sealing? There was a motion a couple of weeks ago we talked about here about the magic question. Ann Taylor wanted to make sure that the magic question wasn't used, and she wanted to make sure that certain proceedings were observed in the voir dire process. And I'll link that down below if anybody doesn't know what the magic question is. But that motion, the judge issued an order saying it shall be sealed, not just sealed, but sealed immediately, just immediately. And that really struck me. So I guess you're right that there's room for just taking a second look. And is that what you think is happening now?
That's my best guess. I can't come up with any rational explanation for the order otherwise. And as you've raised, I mean, that was a puzzling request to seal. I mean, everybody knows what the magic question is. It relates to a judge trying to rehabilitate a witness that perhaps one side or the other thinks they have sustained or been laid sufficient groundwork for a cause for challenge. And the judge says, well, hey, can you put that aside, despite all of that, despite what you heard, despite what you just said? Can you put all that aside and give Mr. Kohberger? But so there's nothing in those type of questions or jury selection process that needs to be sealed. So the defense must have inserted something else into that pleading that rise to the level where the court says, hey, listen, this is going to prejudice the right to a fair trial, or it's going to potentially cause harm to a witness or jurors or something else. So I am probably as stymied as you as to why, but the only rational explanation is he is reviewing it and perhaps will be unsealing or unredacting some of the documents that have been filed.
Now, you had mentioned at the very beginning of our interview here that you pointed out that the Boise, Idaho judge has moved the trial date back from June 2nd, which is when it was going to start in Moscow, to now August 11th. Do you see anything significant in pushing that back, or was that just a scheduling matter?
I think it was probably a scheduling matter. I think, number one, it gives him a little more time to get familiar with the case, which I'm sure he wants to do and get his arms around it, which, again, may relate to what we've just discussed. And I think probably from the case being assigned to him, both from a courtroom, staffing, security, jail, communications with attorneys, all of those aspects, that probably gave them some extra time to make sure that everything was going to be in order come trial time.
One of the first things that happened when the case ended up down in Boise was that the defense filed 13 motions to strike various aspects of the death penalty. And then the prosecution came back and filed 14 motions objecting. Now the defense actually, I think the day before we're recording this, filed another motion that's about 134 pages. And they're fighting over the death penalty, which, as I understand it, it's codified in statute in Idaho. So I know my crystal ball is broken, but what is a court likely to do with all of these motions? And why would they be filed at this
The
level?
reason they're filed at this level is even though, as the defense concedes in some of these motions, that the present court rulings from the Idaho Supreme Court do not support these motions as a matter of law, and that the trial court is bound by the Idaho Supreme Court's decisions on them, they're filing them in the event that a later Idaho Supreme Court or U.S. Supreme Court declares the death penalty unconstitutional as cruel and unusual punishment. On some of the other motions that they have filed as to the aggravating factors, that some of those factors may be later declared to be unconstitutional as void for vagueness. So it is being done really to preserve appellate review in the case of a change of state or federal law regarding the constitutionality of the death penalty. I do not expect any of them to be granted at this level. The one argument and motion that is intriguing is the one that relates to the manner of execution should the death penalty be imposed, because that is, an issue that is on the forefront, particularly in Idaho with the Thomas Creech case, and in other states in which the methods that have been ruled constitutional for in the past, you can't get the drugs and chemicals needed anymore. So that is an intriguing motion, but it right now is premature for a number of reasons, and I don't expect there to be any relief granted on it, but it raises a very interesting issue in the future.
Yeah, the pleadings that we've looked at and not gone too far into it, because our overseers at YouTube don't like certain language. And Dr. Wolf, who goes way back to the OJ case, wrote an affidavit that goes way into detail about what physically happens when the DP is being administered. And then there's this new 130-page motion filed by Ann Taylor just before we went on with recording this episode. And it goes into a lot of detail of, why we shouldn't allow these modes of enforcing executions, whether it be by lethal injection or whether it be by firing squad. So they went into a lot of detail that we just can't talk about on here, but it's all in the public record. I think what you're saying, and correct me if I'm wrong, is that, and as attorneys, we know this, you can't appeal any issue that you haven't raised at trial. Maybe non-attorneys don't realize that, but if you forget, that's why you always see attorneys go back to their desk before they rest, and they check their notes. Before they let a witness go, they check their notes to make sure that they hit all the major points. Because if you don't raise an issue initially, you can't raise it later. So I think what you're saying, correct me if I'm wrong, is they brought all of these motions so that if Mr. Kohberger is convicted, only if he's convicted, then they can bring this all the way up to the Idaho Supreme Court and also the U.S. Supreme Court. Is that why they're doing it?
Yes, essentially you're correct. They're being very careful to protect the record and make sure they haven't waived any potential appellate issues. Just for a minor correction, the law is that you really can't waive a constitutional issue. So if it's a constitutional issue, you may be able to raise it the first time on appeal, and most of these issues are of constitutional magnitude. But be that as it may, they are protecting the record. They want to make sure that they aren't accused of ineffective assistance of counsel for waiving any potential appellate issue. The trial court is bound by the present rulings from the Idaho Supreme Court, and they've acknowledged it as such. So they are making their record for appellate purposes.
On a personal note, and I asked you before we started this episode if I could ask you about this. On a personal note, I did not know this about you. You have daughters who went to both University of Idaho and to Washington State University in Pullman. What insight do you have from your daughters about that area and how tight those two communities are?
Well, I think, yes, I have identical twins who are now 35 years old.
Wow.
And they initially were going to go to University of Washington, and one was going to go to University of, I think, Vancouver or University of British Columbia in Vancouver, until they realized that they would be hours apart border crossing. So at the last minute, they switched and went to University of Idaho and Washington State University, 10 miles apart, so they could see each other, but also in their respective campuses, not be called a Curtis twin. So from that, I was down there frequently. My daughter, who went to University of Idaho, graduated and then went to Washington State University, did her master's work there, and then taught there for 6, 7, 8 years, and maintained a residence in Moscow for most of that period of time, because she preferred that town. My other daughter went undergrad to the Washington State University. So they were back and forth between each campus quite a bit. And as it relates to the closeness of the communities and the regions and the connections that we discussed as reasons for the change of venue in Latah County, it's just so interconnected that I believed that the judge would be forced to change venue, which they did. But it gave me insight. I mean, Christie's, one of my daughter's apartment was just blocks away from the house where this occurred. Her sorority is
really
about a block and a half to 2 blocks. It's very close to sorority row there on the campus. I mean, she knew the house immediately when they showed the pictures of it, because she drove by it all the time, and it was a rather busy house.
Now, why did you say that? Why did you? I'm stopping you right there. Why did you say it's a very busy house?
It had a reputation previous to these individuals being there as a house that was rented, and that there was a substantial amount of social activity. And that's not, I'm not saying that in any bad or negative way. It kind of had that reputation.
Very lawyerly of you to put it that way, I would say.
Well, it's very close to the campus, and it's a large one. It houses, the 3 bedrooms. It's very close to, the Greek houses there. And so, I mean, that was just it. I mean, nobody said, listen, that's a bad house, or there are bad people by any means.
It's a party house.
Well, yeah, I mean, social. I don't know that, from the standpoint, I don't even know the history. I haven't read anything that has said, listen, we had a lot of 911 calls for loud parties or anything like that. But there's a lot of activity. I mean, a lot of people, I think popular people lived in that house.
Okay. Now, I don't know how far down into the weeds of the case you want to get. And again, I know that my crystal ball is broken, and I don't know if yours is working or not, but you've done some work on the Innocence Project. That's one of your pet projects. You're a very experienced criminal defense attorney. We have 2 different camps in our comment section down below, and we encourage people to comment. But one camp says, we know he's guilty. The DNA's in the place, and they have the car driving by. How can you even question it? We know. And then the other camp says, how can you even say he's guilty? They don't have anything. That DNA was planted. There's 22,000 Hyundai Elantras. So we have 2 camps. There are very few people like us that say, look, we're going to wait for the trial. There's so much stuff that's been sealed. We don't know. And anybody that says they know, no, you don't. So I want to get out your crystal ball. And as somebody that's worked on the Innocence Project, do you think that this case is ripe for probably an unfair question to ask you, but do you think this case is fair for a wrongful conviction? Or do you think that they're pushing the little bit of evidence that they do have too hard?
Well, I would say this. At this point in time, neither camp has any really solid basis to rely on their opinion. We don't know enough. I would say from an Innocence Project standpoint, obviously they wouldn't even be screening a case unless there's a conviction, number one.
Right.
And because of their limited resources, they primarily are looking at death penalty cases in which scientific evidence or forensic evidence can now be used to prove innocence that wasn't available at the time. So I'm not sure we're in that situation or not. And because of the amount of sealed evidence, until we get the testimony as to how the DNA was retrieved, how it was preserved, how it was tested, how it was analyzed, a lot of other things, you couldn't even make a informed opinion as to whether it's a case that the Innocence Project would look at. But if it does turn out that there are, I'm sorry.
Oh, no, I'm sorry. I didn't mean to interrupt. I was just going to ask about your familiarity with DNA evidence and how quickly like a turnaround for something like that would be. Like, is DNA something that, because you mentioned like the quality of it and stuff, I guess I was just curious, like, do you know any of the processes behind that, or do you know, just like timelines for it? Is it something that they can figure out fairly quickly, or is it more of a complex issue?
Are you speaking as for the defense or prosecutors to the testing process, or for the Innocence Project who would be examining it?
So I guess I'm curious. I'm dying a little bit for all of it. I guess I'm just curious about specifically, I guess more in the prosecution's case, like how, when you acquire that, what do they do with that? And then I guess you mentioned the innocence process. I'm curious also how that plays into that as well.
Let me try to do a bit of a primer as to what we're talking about here. So what you have is initially a blood sample that was retrieved and was then sent for testing through genetic genealogist labs. In other words, private or company-owned databases of individuals who had voluntarily supplied their DNA, generally for purposes of understanding where you came from, et cetera, as opposed to the law enforcement database of either convicted or people charged with felonies, depending on each state's requirements for DNA testing.
Good answer.
So what you had was, through this genetic genealogy chain, I believe 2 different laboratories determined that it came from a relative of this particular family, based on putting together, there's a couple different ways they can examine it as well. And so it is most likely a relative or a son of or a cousin of or something relative of, versus when you run it obviously for a direct match, saying that is the same DNA as the person in the crime lab. So the question, and I think perhaps the very first time we talked, maybe we talked about this issue, perhaps it was another interview, I apologize if it wasn't. But I believe that the defense is going to be mounting a challenge, because there are strict protocols for how the DNA is taken from a suspect for law enforcement purposes, how it's preserved, how it is documented, when they test it in state laboratories, as with all forensic evidence, and gunshot residue and toxicology, etc. So the question is whether these genetic genealogy, which has only come really into play in the last 3 or 4 years, it kind of links through relative family associations and private laboratories, whether the standards meet or should be considered trustworthy enough to be used as evidence in a criminal trial. I mean, we know now, obviously, lie detectors can be used for investigation, but they can't be admitted as evidence.
Right.
Because they're not deemed reliable enough.
Right.
So I think we talked. So we see that the defense is asking for discovery as to how, and they want to know every little piece of evidence from these private things as to what the state gave to them, how, when they gave it to it, who handled, what's the chain of custody of the item, what were their testing procedures, what were their oversights, what were their peer reviews, and they're going to mount a challenge trying to suppress the DNA, saying it's not reliable. Once they focused on Kohberger, even though, as I understand it, I think once they were able to finally narrow it down and then finally get a sample, they've been able to match it directly. So they say.
Right.
But so that's the issue right now on DNA. And I think that's the issue defense is going to be seizing on, is that genetic genealogy and the laboratories that produce the results are not subject to the same standards as the national database and state databases on DNA, if that makes sense.
Makes a lot of sense. Yeah.
Thank you.
Okay. Well, we really appreciate your time. Do you have any closing thoughts for you? The whole idea of doing this interview is now that the Kohberger case has now been moved from Moscow and it's in Idaho. I mean, it's in Boise, and we've had some time to kind of watch things percolate through. I just was wondering what your overall impressions were. So having said that, do you have any closing thoughts for us?
Well, I think that really the real substantive type of motions relating to evidence, there will be some discovery battles with the defense claiming the state hasn't given them anything, the state saying the defense is overreaching and they've done it multiple times. So we're going to see discovery battles, but we're going to see the motions to suppress. The substantive motions relating to the mechanics of what's going to go on trial are what we're going to be seeing in the upcoming scheduling orders, in which the judges said, listen, I want these issues aired early. I want them, here are the deadlines for them. But I tell you what, even though there's a deadline, you come to me with a discovery issue that you knew about 3 months ago and you waited to the deadline, you might be in a little bit of trouble for doing it. So we're now going to start over the next 8 months, or really the next 6 months, start getting to the meat of the matter, really, in terms of what is going to be the state's theory, what's going to be the defense theory, who the witnesses are, what evidence they're relying on. And I think that will obviously lead to opening up perhaps some of the sealed records, or at a minimum, give us a much better idea of what evidence the state has and is relying upon, and how the defense is going to attempt to counter that evidence.
Yeah, two of the motions you just mentioned are big, and he has put deadlines out for the motions in limine and the motions to suppress. I think that's where the real activity is going to be. And I'm just wondering, I wonder if they're going to keep that stuff private, because half of these hearings have been public and we've been able to watch them on YouTube. Half of them have been behind closed doors. So I'm just wondering whether they will allow us to see those hearings on motions to suppress or motions in limine. I'm guessing not, because if the motions are allowed, then that evidence doesn't go in and they don't want the public to know about it. That's my guess. I don't know if I'm guessing correctly or not.
I think I would lean a little bit the other way. I think the presumption is, that's what happens in cases. And, at some point in time, the public's right to be able to review this entire process to ensure it's working the way it's supposed to, lends itself, absent probably an extremely compelling case. I would expect to see the vast majority of the suppression motions to be able to be viewed by the public.
Well, I hope you're right. I really hope I'm wrong, and I hope you're right. I've talked several times in previous episodes about the Nebraska Press Association case where, the Supreme Court said, look, yes, there is a valid public right to know. And I know we've had commenters down there saying, no, the public has no right to know. But the Supreme Court said there are two interests. There's the Sixth Amendment right to a fair trial, but there's a valid First Amendment right for people to know. And as a former reporter, I always err towards the public having the absolute right to know, because we pay for the courthouses, we pay the judges, we pay the attorneys on both sides of cases like this. But, a lot of people will come out and say, why publicize all this if certain evidence is going to be suppressed and not allowed? We're just tainting the jury pool. So I don't know. We just have to watch what the court does with that.
We do, but just in quick response to that, I think we're of the same ilk when it comes to this position. You can't trust the judiciary system to just, that's what it comes down to, is we need to be able to trust our judicial system.
Right.
And if you say, we're going to tell you the result, but we're not going to show you the process we reached to get to that, that, that's not how we're set up. Now, obviously,
Right.
we both recognize there are certain concerns that do outweigh it, but it's a heavy burden to outweigh the public's right to know, the press's right to know. And there are ways to redact certain things. Obviously, personal information can be redacted, et cetera. So I think this judge is going to lean, more towards disclosure than we have seen so far in this case.
Interesting.
Now-
Well, we're not in church, but I'm going to say amen to that. I hope you're right.
Okay.
You're right.
That being said, I think this is what you should do. I think you should put in a public request and ask for all the other people that have put in public requests for unsealed documents and see how many people have been trying to get these things and how many
Well-
times the court's been denying them to date.
I've already done one, and I have two more. I have two more in my mind, but I don't want to flood them with requests because I want them to deal with the
I
first
know.
one first, and then yes, I have two more in the back of my head that I'm going to do. But maybe that'll be the third one. Thanks for the idea. Thank you so much for your time. Thank you so much for your time this afternoon. We appreciate it.
Yeah, thank you so
All
much.
right, thank you for
joining
having
us.
me.
Thank you.
Be well.
Thank you. You too.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.